Hello and welcome everyone. This is IESBA's Engagement Team Group Audit webinar. My name is Saadiya Adam and I am a principal at the IESBA and I will be the moderator of this event today. Let me start by introducing our presenters, Ms. Caroline Lee and Ms. Saadiya Adam. They are both members of the IESBA Engagement Team Group Audit Task Force and they participated in developing the revisions to the IESBA code, the revisions that we are going to discuss today. Caroline was an IESBA member between 2017 and 2022 and served as a deputy chair in 2021 and 2022. She's a partner at KPMG in Singapore with over 30 years of experience in the public accountancy profession. And she was KPMG's Asia-Pacific head of quality and risk management from 2015 to 2022. Saadiya is the Senior Professional Manager for Standards at the Independent Regulatory Board for Auditors in South Africa. She's also the Secretariat at the Committee for Auditors Ethics and the Committee for Auditing Standards in South Africa. Saadiya has been an IESBA member since 2021. So welcome, Caroline and Saadiya. Thank you for joining us today. And before we start the presentation, I would like to mention a couple of house rules. If you have any questions at any time during the session, you can submit them by using the Q&A icon in the Zoom control panel below. And Caroline and Saadiya will answer as many questions as time allows at the end of the presentation during the Q&A session. Please note that our webinar event is being recorded and will be posted on the IESBA's website. This means that you can access it later and perhaps you can share it with your network as well. So now, without further ado, let me turn to Caroline, who will be our first presenter today.
Thank you, Sylvia. I would like to add my thanks to everyone for joining us today from wherever you are in the world. And thank you also to Saadiya for co-presenting during her fasting month. Diana, if we can move ahead. So during today's webinar, we will briefly cover the background of the project. Diana, if you can move to slide 2, please. Can we go to the agenda slide?
Apologies, Caroline. We are having some technical issues. One moment, please, and we can continue the presentation.
Okay, no worries. So I will just continue and we'll have the slides come up when they're available. So during today's webinar, we'll briefly cover the background to the project. We'll then go into key elements of the final pronouncement on the definition of engagement team and new group auditor independence requirements in section 405 of the code, including breaches at a component auditor firm. Thanks, Diana. We'll end the presentation by highlighting the effective date and transitional provision before we take your questions. So on slide 3, just setting the background on the next slide. Yes, in December 2016, the IAASB approved a project proposal to revise ISQC 1 on quality controls for firms that perform audits and reviews of financial statements and other assurance and related services engagements, ISA 220 on quality control for an audit of financial statements, and ISA 600 on special considerations on audits of group financial statements, including the work of component auditors. This IAASB project resulted in a change in the definition of an engagement team in ISA 220 revised to recognize different and evolving engagement team structures. It should be noted that the definition of engagement team in the extant code was developed based on the engagement team definition in Extend ISA 220. The ISSB clarified in ISA 220 revised that the independence requirements applicable to members of the engagement team are specified in relevant ethical requirements, which, as defined in ISA 220 revised, include the IESBA code. When the IAASB issued an exposure draft on ISA 600 revised in 2020, some respondents raised concerns regarding the application of the International Independence Standards in Part 4A of the Code in the context of an audit of group financial statements. In light of this, and following coordination with the IAASB on the ISA 220 project, the IESBA approved a project to address the implications of the changes in the definition of an engagement team from the code's perspective to make clear that the code's provisions apply to the various individuals who are part of the engagement team under the revised definition. Component auditors outside a firm's network who perform audit procedures for purposes of a group audit are part of the engagement team based on the revised definition in ISA 220 revised. As a result, the IESBA project covered revisions to the International Independence Standards to provide clear and consistent guidance concerning the independence of component auditors outside the group auditors network. Additionally, the IESBA agreed that it was necessary to go beyond individuals included in the engagement team definition and consider the independence framework applicable to a component auditor firm. There was close coordination with the IAASB every step of the way on this engagement team group audit independence project. An exposure draft was issued in February of 2022 for public consultation, and this attracted written comments from 49 respondents representing various stakeholder groups. Going on to the next slide, careful consideration was given to all feedback from the public consultation, including questions on independence considerations for the component auditor firm and group audit team members outside the group auditor firm's network. Extensive outreach activities were undertaken with the consultative advisory group, regulators, firms, and other stakeholders as the task force worked to revise the proposals in the exposure draft. The key revisions to the exposure draft proposals include clarifying and aligning the definition of the terms group audit client and component audit client to the Extend Code's definition of audit client, clarifying the guidance on which types of experts are included in the definition of engagement team and audit team, including new requirements on communications between the group auditor firm and the component auditor firm to complement requirements in ISA 600 revised, setting out guidance for determining the period during which independence of a component auditor firm outside the group auditor firm's network is required, providing a more targeted and proportionate approach for independence considerations applicable to group audit team members within or engaged by a component auditor firm outside the group auditor firm's network, providing enhanced guidance regarding the provisions prohibiting a component auditor firm outside the group auditor firm's network from holding financial interests in and having loans involving the group audit client. Clarifying the requirements for component auditor firms where the component audit client is not a public interest entity, but the group audit client is a public interest entity. providing guidance where there's a change in the component auditor firm or in the group audit client's circumstances, enhancing the consistency of the process where there's a breach at a component auditor firm within or outside the group auditor firm's network, and enhancing and clarifying the group auditor firm's communication with those charged with governance of the group about any breach at a component auditor firm level. The IESBA unanimously approved the proposed revisions in December 2022, and after the PIOB certification, the final pronouncement and the basis for conclusions were released in February of 2023. The final pronouncement is effective for audit and group audits of financial statements for periods beginning on or after 15 December 2023. So now we'll go on to the next slide, and I will cover revisions to the engagement team definition. So Diana, if you can go to slide 6. The extant definition of engagement team in the code applies to both audit and other assurance engagements. In contrast, the definition of engagement team in ISO 200 revised applies only to audit engagements. However, ISQM 1 addresses engagement teams for engagements other than audits. Specifically, the term engagement team as defined in ISQM 1 applies to any team performing procedures on an engagement within the scope of ISQM 1. And that would be an audit, review, other assurance, or related services engagement. In ISQM 1, the IAASB has established a broader definition of engagement team, which refers to the performance of procedures on an engagement. So all partners and staff performing the engagement and any other individuals who perform procedures on the engagement, excluding an external expert and internal auditors who provide direct assistance on an engagement, are falling within the definition of engagement team. So in light of this, the IESBA revised the definition of engagement team in the glossary of the code to align with the definition of engagement team in ISQM 1, with explanatory guidance to clarify the nature of the various teams in reference to parts 4A and 4B of the code. So revisions to the engagement team definition aim to acknowledge new service delivery models, and it also covers individuals in different locations or outside the firm who perform audit procedures and are also therefore engagement team members. The engagement team is part of the audit team definition. The audit team definition now involves individuals engaged by the firm who can directly influence the outcome of the engagement. So this is as a result of ISQM 2 on engagement quality review. So these individuals are included as part of the audit team, regardless of whether they come from within or outside the audit firm. Engagement team and audit team members need to comply with the relevant provisions of the International Independence Standards. Parts 1 and 3 of the code do not mention engagement team. These parts refer to team in general. Going on then to slide 7, where we'll touch on the definition of audit team. So as I mentioned earlier, engagement team is part of the audit team definition. And so you'll see on the left side, engagement team refers to all partners and staff performing the engagement and any other individuals who perform procedures on the engagement. And it excludes external experts and internal auditors who provide direct assistance on an engagement. Any other individual includes those outside the audit firm's network or another service provider. Touching on external experts, in the extant code in the glossary, there is a definition of external expert, and an external expert is an individual or organization possessing skills, knowledge, and experience in a field other than accounting or auditing, whose work in that field is used to assist the professional accountant in obtaining sufficient appropriate evidence. Such experts are not considered part of the engagement team. However, ISO 620 requires the professional accountant to evaluate the objectivity, competence, and capacity of that external expert. So there is now clarification on which types of experts are included in the definitions of engagement team and audit team. Although an individual from a service provider would be covered by the International Independence Standards, the IESBA did not believe that the scope of the International Independence Standards should be extended to cover the organization that provides the human resource, other than in the case of a component auditor firm outside the group auditor firm's network. This is because such an organization does not perform the audit work. Accordingly, the IESBA was of the view that it would be disproportionate to bring such an organization into the scope of the International Independence Standard. On the right side of the definition, the audit team definition now involves individuals engaged by the firm who can directly influence the outcome of the engagement. And this excludes those individuals who cannot directly influence the outcome of the audit engagement. So there are three subgroups of individuals who are involved in the audit and are therefore caught within the definition of audit team. Going on then to the next slide, where it's the application of the same audit team definition, but in a group audit context. So the group audit team comprise of the engagement team for the group audit and those who can directly influence the outcome of the group audit engagement. So as mentioned earlier, engagement team and any other individuals who perform procedures on the group audit engagement. And it excludes external experts and internal auditors who provide direct assistance on the group audit engagement. Any other individuals outside those of the group auditor firm's network or other service providers are included within this definition of engagement team. And then on the right side, the group audit team definition includes individuals engaged by the group auditor firm who can directly influence the outcome of the group audit engagement. And it also includes individuals at the component auditor firm outside the group auditor firm's network who can directly influence the outcome of the group audit engagement. And it excludes those individuals who cannot directly influence the outcome of the group audit engagement, even if they can influence the component audit. So going on to the new section 405 on group audit. So next slide, please. So first, I will cover the new defined terms in as a result of section 405. So on slide 10, the code now includes new defined terms for the purposes of specifying independence provisions for group audits. These definitions are based on or are in line with the terms established in ISO 600 revised, although some terms are slightly different so as to be consistent with the rest of the code. For example, ISO 600 revised sets out requirements for group auditors and component auditors, whereas Section 405 focuses on the independence of group auditor firms and component auditor firms, in addition to the personal independence requirements of individuals participating in the group audit or group audit team members. The definition of the terms group audit client and component audit client are aligned to the extant code's definition of audit client. Going on to slide 11. So this section 405 specifically focuses on independence in the context of a group audit. A group auditor firm and its network firms is required to apply independence provisions applicable to an audit firm and its network firm in Part 4A. So group audit team members within the group auditor firm's network need to comply with independence requirements applicable to audit team members. This approach is in line with the extant code provisions. Stakeholders had expressed concerns regarding independence considerations for component auditor firms outside the group auditor firm's network. And so Section 405 addresses these concerns by having independence requirements for individuals who are group audit team members. And there are also requirements related to the component auditor firm outside the group auditor firm's network. Section 405 also addresses stakeholders' concerns when a group audit client is a public interest entity and a component audit client is not, and where the component auditor firm is outside the group auditor firm's network. So we'll go further into these in detail in the subsequent slides. So on the next slide, slide 12, this is on communication between the group auditor firm and the component auditor firm. ISO 600 revised requires and specifies matters to be communicated in a group audit. And so in Section 405, we have set out requirements that supplement those in ISO 600 revised. For example, the component auditor firm is required to communicate any independence matter that requires significant judgment and the component auditor firm's relevant conclusion to the group auditor firm. And the group auditor firm is required to communicate necessary information at appropriate times to enable the component auditor firm to meet its responsibilities under Section 405. So this applies to component auditor firms within and outside the group auditor firm's network. The respondents to our exposure draft agreed with the enhanced communication about relevant ethical requirements that are applicable and in relation to the group structure or related entities. On the next slide, now we'll touch on independence of the component auditor firm outside the group auditor firm's network. So the component auditor firm outside the group auditor firm's network shall be independent in accordance with the provisions of Part 4A as it relates to the component audit client, F in this case, and its downstream controlled entities. So all entities controlled by F. As it relates to the group audit client A, the component auditor firm outside the group auditor firm's network shall be independent of the group audit client with respect to financial interests and loans and guarantees. In relation to all the other entities and components that you see on this slide that's set out in amber, the component auditor firm outside the group auditor firm's network shall consider any relationship or circumstance the component auditor firm knows or has reason to believe might create a threat to their independence. So circumstances and relationships that might create a threat to their independence include, for example, a financial interest in a joint venture. So the component auditor firm shall evaluate and address threats to independence and shall notify the group auditor firm of independence matters that required significant judgment. And if the threat to independence cannot be reduced to an acceptable level, then the component auditor firm cannot participate in the group audit. So the entities, the list of related entities that you see in the diagram is not exhaustive, and this only serves to demonstrate the potential scope of related entities of a group audit client and other components. If we then go on to slide 14, independence provisions that apply at a group level apply throughout the entire group, including to the component auditor firm outside the group auditor firm's network. So if the group audit client is a public interest entity, the component auditor firm of a non-PI component is required to apply the PI provisions with respect to the component audit client. The component auditor firm of a non-PI component complies only with independence requirements applicable to permissibility of a non-assurance service to the audit client. And this excludes provisions addressing communication with those charged with governance on the provision of non-assurance services. So the pre-concurrence, the transparency provisions are excluded. The other requirement is on key audit partners and partner rotation. So questions regarding scalability of this requirement when providing non-assurance service to a non-significant component are also addressed in the code. So I would like now to hand over to Saadiya, who will cover the remaining key provisions related to group audit independence. Saadiya, over to you.
Thank you, Caroline. So I will be taking you through the independence requirements for the audit team members. the extant code already addresses personal independence required in respect of an audit client. It says individuals from the component audit firm within the group auditor firm's network who participate in the audit of the component are effectively required to comply with the same independence requirements that apply to the engagement team at the group audit firm. However, as Caroline has explained, the engagement team definition now includes individuals outside of the group auditor firm's network. So what are these independence requirements, and do they follow the same independence requirements of that of the network? And then I'm going to take you through an explanation of, if not, what was the reason. So during our consultation process, we heard concerns from firms and professional bodies on aligning these requirements, and they were largely in 4 categories. It is burdensome for the component auditor firm outside the network to track individual audit team members across all the related entities and other components within the group audit client. Additionally, the component auditor firm outside the group auditor firm's network may not have sufficient information about all the entities in the group, especially entities that are outside the chain of control of the component audit client. There are potential practical challenges for component auditor firms outside of the group auditor firm's network in monitoring independence of their group audit team members with respect to all related entities and other components within the group audit client without access to the network's independence monitoring system. And then there was a concern about very large multinational groups or multi-industry audit clients. And this may be exacerbated due to mergers, acquisitions, and changes during the course of the engagement. The IESBA finalized these amendments in a balanced approach. So by achieving the same independence outcomes with allowance for global operability and likelihood of threats to independence. So this allows a focus on specific chains of commands and avoid the tick box compliance exercise. So let's go through the details of this amendments. Next slide, please. So the IESBA noted that in the context of a group audit, the greatest threat to independence lies in respect of the component audit client and the entity whose group audit financials the group auditor firm expresses an opinion. So these are entities A and F. Therefore, it is appropriate that the code requires all group audit team members, irrespective of whether they are within or outside the group auditor firm's network, to be independent of these entities in accordance with Part 4A of the code. These are highlighted in red. The IESBA also acknowledged that any relationship or circumstance between an audit team member and a controlled entity of the group audit client in the chain of control of the component audit client could also compromise the group audit team's independence with respect of the component audit client. So these are your C's and your F's. So therefore, the IESBA determined to also require audit team members from the component audit firms outside of the group auditor firm's network to be independent of such entities in accordance with Part 4A. This option strikes an appropriate balance on how far to scope in related entities of the group audit client, as well as excludes potentially a large number of entities controlled by the audit client. And those are entities that are not part of the chain of control of the component audit client. For those entities colored in amber, those are all the entities that are not subject to the Part 4A. This doesn't mean that there isn't any requirement. This means there will still be a need to address threats created by relationship or circumstances involving its group audit team members. The component audit firm outside of the group auditor network will still be required to apply the reasonable and informed third-party principle and consider such relationship or circumstances when identifying, evaluating, and addressing threats to the component auditor firm's independence. This is underpinned by understanding the facts and circumstances, including any interest or relationships that might compromise independence. Plus, the professional accountants will be required to have an inquiring mind. That means considering the sources, relevance, and sufficiency of information obtained and being open and alert to the need to further investigate. So let's see how to assess these threats. Next slide, please. So the IESBA considered two options on which an individual will determine their independence in a group audit context. So the first option was, based on a list of all the related entities and other components of the group, they would assess in relation to each entity or other component whether there was any relationship or circumstances that could impact their independence. The other option was to consider the individual assessing whether they have any relationship or circumstance and addressed by the independence standards, and consider whether any such relationship or circumstances was tied to any related entity or other components of the group audit client. The IESBA believes that both approaches are in alignment with the code and the conceptual framework and will result in a similar outcome. However, in the case of the option of starting with the entity, the administrative burden from both the group auditor firm and the component auditor firm's perspective would be disproportionate for a large multinational, multi-industry group relative to the likelihoods of threats to independence. The IESBA was concerned about the potential unintended consequences of the process becoming more tick-box compliance and the period of time that these engagements would take. So given these considerations, the IESBA considered that the second option, looking at the individuals and the threats to independence, would be the right approach as we consider these related entities and other components within the group audit client. Next slide, please. So under this approach, starting with the individual, the member of the group audit team would then or engaged by a component audit firm outside of the group auditor firm's network would be required to notify the component audit firm of any relationships or circumstances the individual knows or has reason to believe might create a threat to the individual's independence in the context of the group audit. Members of the group audit team outside the group audit firm's network might consider any relationship that they know or to believe. So there might be certain circumstances where family members hold directorships and are involved in a financial position, and there might be a heightened risk on those individuals. But if the immediate family member, such as a spouse, is a teacher and doesn't have any director or financial role, then there would be a less likelihood that that individual will have a threat to or would cause a threat to independence. The individual shall notify the component auditor firm. The component auditor firm shall address the threats to independence. The component auditor firm shall notify the group auditor firm of the independence matters that required significant judgment. If these threats cannot be reduced to an acceptable level, the individual cannot participate in the group audit. So this is not a standalone. As Caroline mentioned previously, there's an introduction to promote communication between the group auditor firm and the component auditor firm. And this was leveraged off a requirement in ISA 600 revised. So this includes a communication on key areas of interest and any related entities or components within the group audit client that are relevant to the independent considerations of the component auditor firm and for audit team members within or engaged by the firm. Next slide, please. Another area that the IESBA had to consider was the area of breaches. Even with the best of systems, a breach may occur at the component auditor firm level. It's important to note that this section covers all component auditor firms. This is both within or outside of the group auditor firm's network. Next slide, please. So we can all agree that a breach of a provision of the code is a serious matter, and that is why that there's been alignment. However, the IESBA also noted that in the case of a breach of a component auditor firm within the group auditor's firm network, the group auditor firm also needs to apply the paragraphs in relation to the group audit. So those don't fall away. These are add-ons. There's a 4-step process under which a breach will be assessed. So you either end, suspend, or eliminate the breach and address the consequence. You evaluate the significance of the impact of the component auditor firm's objectivity, determine any other actions to be taken, and then promptly communicate in writing to the group engagement partner. The group engagement partner, on receipt of this here, is required to review any actions or proposed actions taken by the component auditor firm to address the consequences of the breach. So if the group engagement partner determines that the breach has been satisfactorily addressed by the component auditor firm and does not comprise the component auditor firm's objectivity, the group auditor firm may continue to use the work of the component auditor firm in the group audit. In certain circumstances, the group engagement partner might determine that there are additional actions that are needed to satisfactorily address the threat in order to use the component auditor firm's work. The group engagement partner's determination will depend on the specific facts and circumstances using professional judgment and the reasonably informed third-party test. The group auditor firm is then required to communicate the breaches to those charged in governance in writing. Accordingly, Section 4.5 requires the group auditor firm to discuss with those charged with governance of the group audit client the component auditor's firm's assessment of the significance and impact of the breach of the component auditor's firm's objectivity, including the nature and duration of the breach and the action that has been taken or can be taken. They're also required to communicate whether the action will satisfactorily address or has addressed the consequence of the breach, or the group auditor firm will use means to obtain necessary audit evidence on the component auditor firm's component audit client's financial information. Next slide, please. As we approach the end and the effective date, it is important to note that this project started because of the alignment with the changes in ISA 220, but also the alignment with ISA 600. Next slide, please. So it's not surprising that the effective date is for audit of financial statements or periods beginning on or after 15 December 2023. Conforming and consequential amendments are effective from 15 December 2023. We note that this is a short adoption or deadline for implementation. However, it is in the public interest that the ethical requirements are available when ISA 600 revised becomes effective, especially given that the revised definition is integral to ISA 600 revised. Consequently, the IESBA agreed that the changes in Section 400 relating to the revised definition of engagement team, the newer provisions in Section 405, the glossary items that Caroline covered earlier would all be effective for periods beginning for audits of group financial statements for periods beginning on or after December 15, 2023. When it came to the conforming and consequential amendments, it is important to note that the definition of audit client and group audit client make reference to the word listed entity, and this term has been replaced with the term publicly traded entity in the recent revisions to the public interest entity project. So as the changes of PI project become effective a year later in December 2024, the glossary includes two different versions of these different definitions with different effective dates. Next slide, please. Caroline mentioned the changes required when a component auditor firm is providing non-assurance service to a component auditor client, especially if the group audit client is a PI. Thus, the IESBA agreed to include transitional provisions to address the non-assurance services provided by the component auditor firm outside of the group auditor firm's network. And these transitional provisions are in line with the non-assurance service transitional provisions that have recently become effective. The IESBA also determined to provide a transitional provision to address the cases where a component auditor firm outside of the group audit firm network has commenced on an engagement to provide a non-assurance service to a component audit client prior to the effective date. And under the transitional provisions, the component audit firm has entered into an engagement and also work has commenced before December 15, 2023. In this case, the component auditor firm may continue with providing those non-assurance services under the extant provisions of the code until completion of in accordance with the original engagement terms. Next slide, please. I think this brings us to the end of the presentation. I'll hand over to Sylvia for some Q&A.
Thank you very much, Caroline and Saadiya, for this really informative presentation. It was a great overview of the revisions. And I think we have some time for a couple of questions. And I would start with the first question that I think I turn to you, Caroline, first, that we got some notes that it's quite a complex project. And there was a question whether the IESBA is considering issuing any kind of guidance that would provide further insight and examples to some of the questions from the practice.
Thanks, Sylvia. So before I answer that question, just to let everyone know that the materials from today's global webinar will be made available on the IESBA's website, and we'll also send out to all participants via email the link. In addition, the IESBA has commissioned the IESBA staff to develop a staff bulletin to provide answers to frequently asked questions so as to facilitate implementation. So that will include examples and illustrations. Thank you.
Thank you, Caroline. The next question is around the sustainability experts. As it was mentioned that as there is a growing demand for assurance and sustainability information, firms usually use the assistance of sustainability experts to help the engagement team. So the question is that do these revisions, so the recent revisions, and specifically the provisions on experts, address the independence of sustainability experts too? And maybe Saadiya, can I turn to you?
Thank you. It's important to note that experts is dealt in this section in terms of some experts being included in the engagement team, while external expert is specifically excluded. But the area of expert is exciting on its own. It's been mentioned in taxation and other sections, but of course, sustainability is the new section that which has growing interest and growing questions, and this will be addressed in a separate project. So IESBA has embarked on 3 sustainability projects. One of them is dealing with the use of an expert, and it will be specifically looking at the ethics and independence requirements that an external expert in an audit and assurance engagement, so those that are specifically excluded. It will also be looking at experts in the preparation and presentation of financial and non-financial information, and then also involving the employment, whether the expert is the individual or it leans towards the employment or the firm in terms of how far does the reach go.
Thank you very much, Saadiya. Just looking for questions, and I think the next question is about the key audit partners. So it was mentioned that a component auditor firm outside the group auditor firm's network needs to apply the PI provisions applicable to the key audit partners if the group audit client is a PI. So the question is, can an audit partner at the component auditor firm become a key audit partner for the purposes of the group audit? And how would the partner know if he or she is a key audit partner?
So Sylvia, I'll take that. So an audit partner at a component auditor firm might be a key audit partner for purposes of the group audit. An example could be where the group audit client is essentially a Shell investment holding company, and the component audit client is the major operating unit in the group. And the audit partner at the component auditor firm will know whether or not he or she is a key audit partner, because the group engagement partner has the responsibility to make that determination and communicate it to the audit partner at the component auditor firm if he or she is a key audit partner.
Thank you very much, Caroline. The next one is about the communication between the component auditor firm and the group auditor firm. So can you provide specific examples of independence matters that a component auditor firm should communicate to the group auditor firm? And does this communication mean that the component auditor firm needs to inform the group auditor firm about the threats to independence, or only if there is a specific breach to the independence requirements? No.
I'm happy to take this one. So the IESBA noted that ISA 600 put in a provision that requests the component auditor to communicate on the compliance with relevant ethical requirements. So when we considered this at the exposure draft in finalizing these amendments, we created a new subsection that clarifies what type of communication would be required. So this includes any independent matters that require significant judgment. And in relation to those matters, the component auditor firm conclusion about whether the threats to its independence are at an acceptable level and the rationale for that conclusion. So to answer your question about whether every threat or whether it's a specific breach, I think it's in between there, because not every threat might require significant judgment, but not every items that might not be a specific breach might require significant judgment. So the professional accountant will need to consider which ones fall within these two categories.
Thank you very much, Saadiya. And I think the following question is about the application of the reason to believe test that we were, or reason to believe principle that we were talking about today. So the revisions require the application of the reason to believe principle from individuals to identify the threats to independence with respect to more distant entities within the group. And the question is that, does this mean that they only need to consider and report on the relationships that they know about? So eventually they can turn a blind eye and not know about certain facts?
So, Sylvia, I'll take that question. So they definitely cannot turn a blind eye. And, if it's facts, they ought to know. So they can't ignore facts that they know. But the reason to believe principle is a well-established principle in the code, and it already applies to individuals and firms in other parts of the code and other requirements. And the code requires the professional accountant to have an inquiring mind and to exercise professional judgment. So in the context of a group audit and the application of the reason to believe principle, it therefore requires an understanding of the facts and circumstances, including any interests and relationships that might compromise the independence. So that is a requirement or prerequisite. Having an inquiring mind also involves considering the source, relevance, sufficiency of information obtained, taking into account the nature, scope, and output of the professional activities being undertaken. It also requires being open and alert to a need for further investigation or other action. So the group audit team member, the individual, must understand their particular relationships and circumstances and whether those would require consideration under the international independence standards as it concerns the group audit client. And the IESBA is of the view that this approach actually better achieves the desired outcome by focusing the attention of the group audit team member on the actual relationships and circumstances that could create a threat to his or her independence. But having said that, it doesn't mean that they can turn a blind eye or, plead ignorance. They need to be sure that they make the right inquiries and have an understanding of the facts and circumstances.
Thank you very much, Caroline. And as I'm checking the Q&A box and other questions, we are getting quite specific questions with specific scenarios. So if you don't mind, I wouldn't read these questions to our presenters today, but we will consider these questions while we are developing the FAQs, and we will come back to you maybe after the webinar. But I think we would need more time to actually digest and understand the scenarios that you are presenting for us in your questions. So I think I would take one more question, which is more general, and it's about the written communication between the group engagement partner and those charged with governance. So in the revisions require written communication from the group engagement partner to those charged with governance about the breaches at the component auditor firm. So the question is that why is the form of communication specified here and not elsewhere in the code? And is there a specific requirement in the code on the form and the way of written communication?
So this requirement is new in the code, but it has resulted in consequential amendments to the general breaches section. So written communication will now be required. In considering this requirement, it's the group auditor firm that's going to make this communication, but it's actually something that happened at the component auditor firm. So it's important that the communication is done in a way that is transparent and doesn't leave any room for miscommunication or misinterpretation. So in a written format, this would allow for the feedback to go through from the component auditor firm in what they've received. So there's two types of written communication. You would receive one as a group engagement partner, and then you'd have to make one to those charged with governance. On the type of written communication, this hasn't been specified and will be left to the group engagement partner and the group auditor firm to determine how this communication would be done. But it did say that it needs to be done promptly, so it should be done in the most efficient and effective manner.
Thank you very much, Saadiya. And I think just we got one final question that, as Saadiya mentioned, that there will be different effective date for the changes to the definition of audit client and group audit client. It's chapter 6 and 7. And we got a couple of questions. Saadiya, can you repeat that? What's the reason of these different effective dates, just for clarification? Thank you.
Yes, the reason for the difference is because of the PI project. So the public interest entity project becomes effective at a later date than the amendments that we're currently discussing. And because of that, you would have two definitions in the glossary, one that becomes effective on the 15th December 2023, but the ones that are aligned with the PI definition becomes effective on 15th December 2024.
Thank you very much, Saadiya. And I think actually we have just come to the end of our session. And thank you very much, Caroline and Saadiya, for your excellent presentation. And thank you, everyone, for joining us today. As I mentioned, if there is any questions we couldn't respond during this session, we will come back to you, or we will consider that as part of our FAQs. So as a reminder, the recording of this webinar will be available shortly on the IESBA website. And as we have mentioned already, there will be a staff FAQ. So please follow us or check our website or follow us on LinkedIn regarding the details of these FAQ. And I wish you all a very pleasant rest of the day, and goodbye.